Why do we need data protection? In the digital age, where data is the new oil, guarding privacy has become crucial. The amount of time spent on computers and with digital devices is surpassing the hours spent in human interaction itself. While elected government has the trust of the electorate, data must be protected from unauthorized use. However, there are certain gray areas that gives the government an upper hand when it comes to processing, storing and managing personal data. This is a question that most countries across the world continue to struggle with. Privacy is a recognized fundamental right in India, though it's not explicitly stated in the Constitution as a fundamental right. But the Supreme Court, in the leading case of Justice Puttaswamy versus Union of India, recognized privacy as a fundamental right. Privacy is a part of right to life, dignity and equality. Like all fundamental rights, the right to privacy is protected by the constitutional courts in the country. In the digital age, where data is the new oil, guarding privacy has become crucial. After the judgment of the Supreme Court, a data protection law was much needed for India with its booming online presence and growth. The Digital Personal Data Protection Act of 2023 is the second version of the bill introduced in Parliament and the fourth overall. An initial version was prepared by a committee of experts and circulated for public feedback in 2018. This was followed by the government's version of the bill that was introduced in Parliament in 2019, the Personal Data Protection Bill of 2019. This version was studied by a parliamentary committee that published its report in December 2021. The government, however, withdrew this bill and in November 2022 published a fresh draft for public consultations, that is, the draft Digital Personal Data Protection Bill of 2022. This draft was quite different compared to the previous versions. The 2023 law is based in significant part on this draft. The DPDP Act is a significant step towards enhancing online privacy in the digital age. It aims to protect personal data and the privacy of individuals whose data is collected. This act will replace Section 43A of the Information Technology Act 2000 as well as the Information Technology, Reasonable Security Practices and Procedures and Sensitive Personal Data of Information Rules 2011. Why do we need data protection? As individuals, we are constantly sharing data with private companies, governments, and other individuals. At no other time in history, such vast reserves of data of individuals was available online like it is available today. The amount of time spent on computers and with digital devices is surpassing the hours spent in human interaction itself. An individual has no control over how a private corporation or a company may store their data, how they may monetize it or use it or alter the shape of consumer behavior. The same concern is with the state as well. The government stores data that it collects from individuals and uses it for various purposes. To ensure that the government does not use the data of individuals for unauthorized purposes is of crucial concern. While elected government has the trust of the electorate, data must be protected from unauthorized use. And this concern is not specific to any particular political party or even to any particular country. Any political party elected to power should not have unfettered access to data of the citizens so that it may at times be used to curb dissent, political opposition, or used for purposes not authorized by law. Consent, therefore, assumes crucial significance. So while there may be plenty of details in the new data protection law, we shall examine the law from the prism of consent given by an individual and how much accountability is ensured from the state and the private corporation when it comes to the use and protection of such data. Consent is at the heart of data protection. Each individual may be made aware by the company or the government the purpose for which the data is being collected. Other than the purpose stated, the data should then not be shared with any other company or individual and not used for any purpose other than what has been stated. The Act encompasses all types of personal data without distinguishing between sensitive and other personal data. The Act underscores the importance of obtaining consent for processing personal data. Section 6 of the DPDP Act categorically states that the consent must be free, specific, informed, and unconditional and unambiguous. Users must be given an opt-out, that is, the option to get out of processing. Personal data can only be processed for lawful purposes after obtaining consent with a prior notice dealing with the data to be collected and the purpose for which it is being collected. Companies that collect and store your information are called data fiduciaries. These companies must disclose how they intend to use your data and then not store and use the data for beyond the purpose or for beyond the period that it is required. The government also has the power to designate significant data fiduciaries. These are those companies that have access to vast amounts of data and information and have the power to affect democratic processes or even at times the security of the state. An individual also has the power and the right to seek correction of the data, completion of the data, and also ensure erasure of the data. Powers given to the government are also considered in the Act. The 2023 Act establishes India's first data privacy law, which aims to create a holistic framework for businesses, governments, and other stakeholders dealing with voluminous data online. However, there are certain gray areas that gives the government an upper hand when it comes to processing, storing, and managing personal data. The exception for consent significantly empower the state by placing the state above that of private entities. For example, Section 7B allows the government to bypass consent requirements if a beneficiary has previously consented to any other government benefit being meted out. This facilitates easier access to personal data for government but also raises concern about the potential data aggregation. Arguably, the government is not obliged to delete the data of individuals even after the purpose has been met. It also includes exemptions for the state concerning investigative, prosecutorial, or national security purposes. For example, Section 17(1)(c) exempts notice and consent requirements for processing data related to prevention, detection, investigation, or prosecution of any of the offences or prosecuting any legal violation. Additionally, Section 17(2)(a) provides a blanket exemption from the entire law for any government agency notified by the government, citing interests of sovereignty, security of the state, integrity, public order, preventing incitement, etc. This suggests that a parliamentary intent to allow certain state agencies a complete protection from the application of the law, that is data protection law. The design of Data Protection Board set up under the law is also slightly problematic. Although it is an independent agency with a limited mandate, the government will determine the selection and appointment mechanism for its members. Whilst the law specifies qualifications for the members, it does not indicate the total number of board members and requires only one to be a legal expert. This is concerning because issuing penalties and directions for non-compliance is one of the key functions of the board. Whilst the new data protection law is a much needed step in the right direction, but its eventual application shall be its true litmus test. At a time when private corporations and the state have vast access to data of individuals, the key question is whether an individual is truly empowered by the law to seek compliance from the data fiduciaries. There is no way to know how an individual's data is used by a company once it is shared. There are no independent mechanisms to ensure compliance or ensure continuous audit. This is a question that most countries across the world continue to struggle with. Ensuring compliance and protecting individuals' rights and interests is the biggest challenge of the digital age.